right. I'm Peter Blumenthal, your president-elect. Dr. Sui is unavailable tonight, so I'm having to take his role. I'm very proud to introduce Ms. Alexandra Garcia-Watts, a lawyer practicing in Montclair with bar access both in New York and New Jersey. She has an interesting curriculum in that she received a bachelor's degree in nursing from NYU in '97, then worked as a law clerk at Sills, Cummings, Epstein, and Gross in Newark, handling health law matters. And she attended law school at Seton Hall, where she graduated in 2001, and then gained access to the bars in both New York and New Jersey. Also in 2001, she began working as a Deputy Attorney General for the Professional Board's prosecution section. She has an interesting LinkedIn web page that I recommend to you, because there she provides thumbnail sketches of common problems encountered in medical practices. And I encourage you to look this up. Since 2022, Ms. Garcia-Watts works as a trustee for Holy Name Hospital, and therefore is deeply involved in our medical community. I give you the floor.
Thank you so much, Dr. Blumenthal. So that sounds exhausting, and it is, but I'm really happy to be here. And I really, I'm glad for the opportunity to share some information that, I've acquired over the years. I have been in private practice since 2004, actually, with my first firm in 2005. And my initial focus was defense, but over the years, it's developed also into compliance and corporate structure things. But, time is the best teacher. And the more that I do this, the more I've kind of shied away from a formal approach and like to approach things in a practical, pragmatic manner, realizing that no one needs legalese. We need to just know what to do. And so it's with that, that approach that I'm here. Unfortunately, because I'm sharing screen, I can't see who's here. But I still want to welcome everyone, and please feel free to interrupt me, ask questions. Josh will be kind of monitoring, and he'll shout out to me, because for some reason I can see him. I can't see everybody else. If there's any question, this will be so much more interesting if you all ask questions. And at the end, I'll open it up for any questions and discussions. And of course, when we're done at any time, you'll have my contact information. Please feel free to call and ask. So originally, Josh had asked me to talk about the prior authorization reform. And I immediately thought, oh, yes, and we can also talk about practical tips to ward off payer demands. As I began preparing, I realized that really the prior authorization reform could have been its very own standalone information session. However, I think the practical tips is also important. So we're going to kind of abbreviate the first. There's great information available online. And of course, follow-up questions. If you have any questions in more detail, you can reach out to me after the, anytime, because it is relevant. So I'm just going to move along to my next slide here, which was working before and now is not moving. Why would that be? Let's see.
Yeah, try clicking on the slide deck. That might advance it. And if that doesn't work, click once.
I do. Okay. So because I am an attorney, I do have to give a disclaimer that basically just says this isn't legal advice. Things are so, every circumstance is so unique that, things don't quite fit. So this is really just for informational purpose, introducing some concepts and ideas, giving you some practical tips. but to really assess a legal situation or risk or particular case or particular matter, those have to be evaluated on a case-by-case basis. So I, just have to say that. My perspective and approach as it relates to defending providers is to really emphasize practical tips. This is not scholarly. There are many articles with citations and things available that can explain or are just available. There's so much information. This is really meant to be focused to what's practical to doctors. So let's talk about the Prior Authorization Act. I want to credit Josh Bengal of the Medical Society, who had already written a flyer, I guess, or some sort of bulletin with some important points and facts from the act. And there was no need to rewrite these as they were so effective. But we'll go through them where you see something in italics or bolded other than the title of each section. Those are my additional, points that I want to point out and that I thought were important. So, prior authorizations are such a headache. I have to say that for my clients in private practice, some have even stopped doing prior authorizations because, it just takes so much time. And if they're out of network, they're really not required to do it. And so they don't. However, the vast majority of providers are still dealing with these things. And now we have some protections that are going to come in January that are going to make this process, I'm not sure about easier, but at least faster. And I do feel more protective of the patients and the providers. So basically for medications now, there used to be a longer wait. Now, basically, if it's urgent, you'll get a prior authorization in 24 hours. And if it's non-urgent, you'll get it in 72 hours. And I have to say that last line I thought was deleted. That's not always the case. That's more a concept, more of the idea that the treating providers have more say, I would say, in deciding whether something is urgent or not. But we're not sure if we can precisely say that they make the decision solely. But that is a big improvement, that there needs to be a decision quickly. And for chronic conditions, basically, you don't have to get it again. If you've gotten a prior authorization for a treatment of a chronic condition or for a defined number, it's good for 6 months. You don't have to get it at each point of service. For diagnostics and procedures, you can read here, they used to have 15 days. Now the payers have to decide within 72 hours if it's urgent. And if it is not urgent, and if it's submitted electronically, they have to decide in 9 days. And if it's submitted by paper, by fax, then you have 12 days. But if there's some medical need for this to be done quicker than 72 hours, the turnaround should be decreased. I would say that there's a lot of back and forth allowed in the regulation. So a payer has that same time frame to request additional information, right? So let's say an electronic request, is for an urgent procedure, and there's 72 hours. They can make a request for additional information within those 72 hours, and then the provider has at least 48 hours to submit that information. And then there has to be a decision as long as the complete information is received. So interestingly, if you miss a deadline, and if the payer misses a deadline, then the provider can proceed as if the prior authorization was granted and was approved. But at the same time, if the provider fails to supply the additional information that's been requested, then the payer can presume that the request was withdrawn and it was not granted. So there's a little responsibility on both ends there to be responsive within the time allotted. It's interesting that actually, I'm going to say something also that I found interesting. There was a section there that basically just said that I think it was a new paragraph, section 6, that said that payers now have to respond to requests for prior authorization, period. And I just thought it was interesting that it had to be stated, to remind, in case there was any doubt, payers, please respond. But I think it says something, it speaks to the dynamic that had been going on or has been going on and that hopefully will change. Going back to honoring an already granted prior authorization, if a patient changes to a new payer, the new payer has to honor the prior authorization so long as obtained in good faith. So that's good to know. And if a patient changes a product within the same payer, a new prior authorization is not required so long as whatever the prior auth was for is a covered service under the new plan or the new program. All right, so it's I think a great addition now that the physician who's reviewing an appeal of a denial has to be of the same, board certified in the same specialty or have significant experience within that same specialty. I was happy to see the peer-to-peer right. Basically, if there's been a denial of a prior authorization and a physician, the provider requests to speak with the physician that's reviewing the appeal by telephone, they have the right to do so, and they must be given the right to the access to do that. This is something I've been doing for quite a while. When it not only when it applies to prior authorizations, but for really any issue where there's some determination of lack of medical necessity or denial of a service or whatever it might be, I love to get the physicians talking. It used to be easier, but it's effective. It's very effective when the providers can speak to each other and work things out. We have yet to see how this is going to play out with the right. If it becomes more common, will it become, sort of just a box to check from the physician that's, from the payer's physician. But, I think the opportunity to make your case, to discuss whatever nuance about this patient that may not be apparent in the record, which, by the way, it should be apparent in the record. But if it's not, it's an opportunity to speak. I have a question here. Can I comment on the percent or ratio of successful peer-to-peer decisions? That's interesting. I can't comment on how, as they apply to this appeals process of prior authorization denials, because this will be new, right? This is beginning now in January. But I can say, in my experience, when the physicians are able to speak to each other, I would say it's a pretty good success rate in getting the. Do they change their mind? I'm going to get back to that, because I haven't had the situation when they were trying to change an individual determination. I've had physicians speak to the reviewing physician when there's been a broader demand to say, you've been doing this test and you should not have been doing this test. It doesn't, was not medically necessary. How we, the payer, define medical necessity. or you were supposed to take XYZ steps according to the standard of care. And they were able to see eye to eye in those situations, but it's not often. So it's hard to give a statistical ratio on how often that happens. I say it's always worth a try. I hope that answered your question. If not, we can get into it again at the end. All right, so going to the insurer reporting requirements, there's now a host of information that needs to be made available by the insurer on their website. And, you know, for me, what's the most important piece here is that when they make changes to, you know, their standard or what's covered or requirements, if a prior authorization is required or not, or other sorts of I guess their specific requirements, they have to notice on their website for at least 30 days prior. And I think that's really important. You know, I think there's going to now be monitoring of these websites to be able to, you know in advance what's coming. I think that's critically important. And if you're in network, you should be monitoring that, or have some mechanism with some professional that can monitor that for you and let you know. All right. One thing I observed in reading the text of this new or updated law, there's still all the buzzwords that the payers use to deny services. You know, inaccurate information, fraud, misrepresentation can still be grounds for denial of payment or clawback or of a pre-authorization. And for example, in the instance when the pre-authorization is good from one payer to another, or the pre-authorization is good for 6 months, or the pre-authorization is good when the program changes, in all of those instances, if there's some determination made that the provider or the patient misrepresented something or gave some inaccurate information, it can always be reversed. Okay, so this doesn't change that. You know, this language is powerful language that I think is thrown around very cavalierly by the payers. So if you see a letter that's accusing you of misrepresentation or fraud or inaccurate coding or billing or documentation, just know that this is common and there are reasons why they're using that language, and we'll get into that a little later. Any other questions from here? All right, so that's, you know, in a nutshell, what we have about the prior authorizations. And again, if you have questions, we can go back to them. I wanted to just kind of go to the basics of how payers are contacting providers now, right? And they're used to, you know, everybody's used to a record request, and those can be related to a claim that was made and there's, you know, more information needed, or to a prior authorization, more information needed. There could be, I don't know if anyone has received, this one would be nice if I could see everyone by hand, or just to, I'm sure some people in the room have received these overutilization letters, where basically the payer says, you know, we've noticed that your use of, let's say, the 99213 code or 99214 code, you're using that you know, 30% more than other similarly situated providers in your geographic area. And we just want you to be aware of what our requirements are to bill the 99213 and pay close attention to that. No one likes to get this letter, but it is valuable because now you know what they're looking for in your practice. And I don't necessarily think that you have to stop using that code, but I do think it's an opportunity to bolster your knowledge about the documentation requirements for the use of that code, and train your providers once again to understand what that is. It's a little warning. they might send a letter of concern regarding prescribing patterns or medical necessity or documentation. And those can range from, hey, we've noticed this about your prescribing or your practice, and we just want to remind you that, you have to adhere to whatever. Or it could say, we've looked at this issue, we'd like to request more records or information, and they'll have a call with the provider, they'll review more records, and they could go so far as to issue this, entire memo, basically rejecting what the provider's explanations were and saying, we want you to get re-educated and take XYZ course, or we're going to remove you from our network, and they might remove you anyway. I would say at this level, you would definitely want counsel communicating with the payer. I would not respond to a letter of concern without your attorney. An audit, everybody knows what an audit is. You'll see in a slide going further ahead that I think there are no more routine audits, but you certainly still see, you get approached, providers get approached saying, hey, we're conducting an audit, could you provide us XYZ records? Again, because I don't think they're routine any longer, and I'll explain why in more detail. I think at that point there should be someone representing you, and you should not respond to that on your own. Investigation. So everybody is probably familiar with the special investigation units, the SIU units, in the payers, and those can be really, hard letters to receive. The special investigation unit is looking into your billing and coding, and we'd like more information. I think anything in, going down from there should require your attorney to respond to them. Repayment demands, it's, basically we paid you, but now, looking back, we don't think we should have paid you. And so we'd like our money back. And not only do we want our money back for those services, we think that we overpaid you in 60% of the 60% of the instances that we reviewed. So we looked back for 3 or 4 years and determined that we've paid you for this claim 100 times. So we're going to assume and apply that 60% of the 10 records we looked at, let's say, and assume that we're going to extrapolate and say that of those 100 records, 60 of them were overpaid. And so we want our money back. And that's the clawback. That's next on the list. We want our money back for 60% of the claims that we paid for that code. Of course, an attorney should be communicating with them from that point forward. And then, set off for future payments. They might, you might have exhausted the appeals or not appealed because you didn't know, or whatever it might be, and they'll start retaining a percentage or all that of good claims, other claims that are going forward, and keep them. So this is serious. You never want to ignore really any of these communications, with the exception of the first, which is still somewhat benign. When a claim is an individual claim is made and a request for more information is made, I think that's still benign. But what gets tricky is for your staff to know the difference. And we'll talk about that a little further. So again, random audits do not exist. In my experience, and I heard it from the horse's mouth in 2020, but by the time an auditor or investigator reaches out to you, they've already made a determination, in my opinion, and are looking for further evidence to support their conclusion. In 2020, I was at an event in New York for healthcare attorneys, and there were various speakers, and there was one from a payer, and he just explained how back in the day, which, was not that long ago, let's say 10 years ago, when he wanted to audit a provider, he had to make an appointment, go to the office, sit in a conference room. They'd bring him the records, and he would review them. And, it was a very time-consuming process. Now, not only does he not have to go, at that point, what he talked about was that the computer conducted the audit for him. So when he gets to work every day, he sits at his desk and up and the computer pops up analysis of, hey, we've identified that this provider is using that 99213 more than others, and, some data or information. And, they get that information and then they determine, who they want to look at from that. It's very, very easy. So I find that by the time they reach out to you, they've already not only received that pop-up about you, but they've looked at your history of claims. They've looked at records you might have provided in a regular request, or that they get from other means. And what they're actually looking for is very targeted. So often, actually, when my clients get this request, right, for a random audit, I can look at the records that they're requesting and see, it's the same code, or it's the same diagnosis, or there's something in common with all of those, and I know that that's what they're looking for. You can't always, but most of the time, we can see what they're looking for. And a lot of time it's related to that first letter, that the overutilization letter, so we can piece it together. And I like to speak to the auditor and investigator before sending any information, and just offer that we'd like to address their concern without really having to jump through all of these hoops. So what do you want to know? Or if their request is broad, for 60 charts, we'll say, can we agree that we'll come up with a way to select 10 of these that's random, and let's look at 10. You'll look at 10, I'll look at 10 together, and let's have a conversation. I'm always trying to get conversations, the opportunities to speak before findings are issued. And I think that that's that a good healthcare attorney is going to do that. Because you just have the opportunity over and over again to address the reviewer. It lets them know, first of all, that the provider is protected, which is important, because they do go for low-hanging fruit, in my opinion, people that are unrepresented and that will just send them everything that's requested. But also because there are often really valid grounds to push back on. And the earlier you start doing that, the better. All right, so let's talk about some practical strategies at the practice that a provider should always implement to just avoid these sorts of investigations, audits, or clawbacks. Now, I'll just say that I think everybody at some point is going to be faced with them, but these are really protective strategies, even if you are selected for or there's scrutiny to your billing and coding. Make sure that your biller is certified, competent, and insured, including errors and omissions. If the biller is your employee, invest in keeping their certifications updated. Okay, invest in being sure that they are the most competent person out there. You really want that person to be very, very well qualified. They're very, very important. If they are not your employee and instead a billing company or an individual that's contracted out as a 1099, be sure that they carry first all the certifications, that they're competent, they're insured, that they have errors and omissions insurance, and that you have a strong written billing services agreement with them that includes that they will indemnify you if they fail to adhere to the standards of a competent biller and cause you some sort of damage. They should be held responsible to that standard as third-party billers. There's another little rule, and I say little because it's very obscure, although it's been on the books since 2006, I believe. But if you are using a billing company or an individual who is a contractor to you, so not your employee, they should be certified by New Jersey DOBI, the Department of Banking and Insurance, as certified third-party billers. not a lot of people know about this rule. And so far, I have yet to see a provider get in trouble because their biller was not certified. But I have represented billing entities that have had to pay some hefty fines. The statute is a very strict statute. And I'm seeing, and my colleagues too, are seeing more frequent enforcement actions against these companies. So be sure that they are. I think it's critical to implement robust billing and coding compliance strategies. And just to briefly talk about what that could be, basically you are monitoring the practice. You are self-monitoring. You're paying attention to your billing and your coding practices. What are your most common codes? Are all the providers trained to know what are the requirements? What's the difference between a 99213, a 99211, and a 99215? You know, those are the 5 visit categories. What are the different requirements for each one? And are we doing a good job? Are providers documenting properly to support the code that we're using? I am not an advocate of changing how you bill to stay under the radar, because you also need to be profitable and you deserve to be paid for the services you rendered. But if you are billing and coding anything other than the bare minimum, you need to know what the requirements are in your documentation. You have to take that very seriously. Another very practical strategy, it's been bright letter law for quite a while now. All providers must collect their co-pays and their co-insurance payments, and you cannot routinely waive or write off any patient balance. There are exceptions, and when we provide our doctors or our providers with a compliance plan, it includes a financial hardship policy and form. So if there really is a difficulty in making these payments, you can first offer a payment plan, but after that, you should have the patient fill out that form, and in it there's parameters for what will qualify, and a practice manager can make a determination of whether there's a waiver or not. This should be a very small percentage of your practice. I would say not more than 5 to 8% of your visits should be waived, and none should be waived without that form. This may be different if you have, you know, depending on your patient population, you may be working, you know, in a very underserved area, you know, a lot of Medicaid patients or uninsured patients, or, you know, people that truly cannot pay the co-pays. So that percentage may be higher. But I think that attention should still be paid in documenting those instances. I already talked about ensuring the comprehensive documentation. I'm seeing more and more frequently in the past, I would say 5 to 6 years, that there's requests are now being made not just for the medical record, but for the billing and collection records. The payers want to see that the patients are being billed for their co-insurance, for their responsibility. And this is different from their copay. If anyone doesn't know the difference between a copay and a co-insurance payment, just put it up there in the chat and I can elaborate on that. Otherwise, I'm going to assume that everybody knows, but I will say that they're both important to collect. I have seen practices where they confuse the two and they say, oh no, we always collect our copay, but do you also collect the co-insurance? And what happens if you don't, or if you can't prove it, is that the payer then wants their money back. They say that you engaged in anti-kickback, in violations of the Anti-Kickback Act, because it is bright letter law that failure to collect these payments is a kickback to the patient for medical services. And so they want their money back for any patient for whom you couldn't prove that they were billed for and that you collected the co-pays and co-insurance. This has, you know, been a problem in practices where they may collect payments, but they don't allocate them, their system for whatever reason doesn't allocate specifically for what service they're paying. So let's say someone is on a payment plan, or they're, they pay, but they pay slow. If you can't distinguish if the payment they're making is for the service they're there that day or for a prior service and which one, it becomes really difficult to meet the standard and to link up and prove that you've are not writing things off. By the way, never write anything off. I've had clients who've had to go out of business for routinely just saying, yeah, we bill for 6 months, and when they haven't paid in 6 months, we just write it off, and they literally have the note write off. Don't do that. All right, so these comprehensive billing and collection records are important, and that if you ever need to see for any patient what they paid and what they paid for and when, your system should show you that. And if it doesn't, come up with a new system. All right, so one thing that I recommend to my clients is that they identify what are the 10 most common codes that they use. And depending on your specialty, right, it will vary. But what are the 10 most frequent codes that you use? Once you've identified them, take the time, or have, engage someone to do it, or have someone within your practice to look at the specific documentation requirements for those codes by payer. I have had a practice where the head of the clinical committee of the compliance committee, there's a clinical subcommittee, actually makes laminated little sheets, right, for the providers to have at their desk for them to know what are the requirements. If you're going to use this code, this is what your documentation must show. And again, we're not saying use this code. We're saying if you think in your medical judgment that this is the appropriate code to use, make sure that you are meeting the documentation requirement for each payer, because they do vary. All right. And this is not a waste of time. This is actually one of the most important things that you can do. And then train your providers on these requirements. And check, do self audits, maybe once a quarter, grab decide on one of those codes, have some random way to select. For example, we're going to look at the patients on Wednesday morning, every second Wednesday of the month for the past 6 months. We're going to look at the claims that included this code, and we're going to look at the documentation to see if it supports it. And if it does, wonderful. If it doesn't, then there needs to be a little corrective action, a little retraining, and a reassessment in a few months to be sure that that was effective. If a particular provider is the frequent offender of this, they need to be pulled aside, and there has to be some real conversation about that, because this is one of the biggest pitfalls that can get a practice in trouble. Another thing that I've now instituted as a best practice with my clients is to train all staff members that any request that comes in for medical records that is not tied to one particular claim should be shown to the practice manager, and the practice manager, depending on their level of understanding or comfort, will talk to counsel to see if it should be responded to. I have had a matter with a demand in the millions of dollars for an out-of-network provider because their new front desk person could not make the distinction and pulled something off the fax and just assumed it was the same kind of request for records as they're, commonly made for a claim, and started sending a whole bunch of information that was requested that honestly they were not entitled to, in my opinion, as out-of-network providers, and that we would not have provided. So, this is critical. Train everyone in your office to know it's best to err on the side of caution and, take a second glance at all requests. But at a minimum, make that rule. If it's not one, one record for one claim, check with us. Any questions? All right, so the converse to this are what are common pitfalls, right? If you're not training your providers on the importance of documentation and coding, and now if you're requiring your providers to code, are you training them in the, doctors are trained in medicine, they're not trained in coding. And they need that training. More and more I'm seeing where doctors, not only in practice, but hospitalists in hospitals, have to code their own services, right? And they're signing agreements that say they're going to indemnify the hospital if they are coding incorrectly or inaccurately or fraudulently or whatever. And remember that those allegations of fraud or improper are very loosely thrown by the payers. So it's really important that the providers really get trained and understand what are the requirements. And if you're not doing that, I think you're really exposing the practice. Failure to monitor the documentation required, again, for the most frequent codes. Failure to self-audit. So you all might have heard that a compliance plan is a really good idea, right? And it is. I think it's more than a good idea. I think it is essential. And most recently, the most recent guidance from the OIG, which is the real governing authority over Medicare, which ends up being the real governing authority over all, for all payers. They said it's not enough to have this written compliance plan on a shelf in the office. You have to train your staff and you have to check yourself. You have to self-audit and institute corrective actions when there's a mistake. So one of the, easiest audits that when I'm implementing a compliance committee for my clients, we start with really simple audits. One is the easiest is just to be sure that patients are signing their NPP form once a year. That's an easy one. Another one is to check if co-pays are being collected. And that's a really easy one. And it's an easy one to institute a corrective action plan. You might have done this audit and found that co-pays are only collected in 75% of patients or less. And so there's a one-page corrective action plan that your attorney can help you write that basically says, we've identified this, we're retraining everybody, we're going to put reminders at each station. Our patients are going to get written reminders. There's going to be a sign at the desk that we're going to collect our co-pays and why. And in 3 months, we're going to reassess. And hopefully we've gone from 75% to 85%, or, we're seeing improvement, and you can document that. And if ever there's a question on whether this practice routinely waives co-pays, you can show that, no, we don't. Actually, we've been monitoring ourselves on this process, and this is what we're doing, and we're paying attention. Having a robust compliance plan like that and having a self-audit process and correcting yourself is a really good defense when a mistake is actually made. Mistakes get made. We are not yet all computers working. There's still real people sitting behind there checking patients in. People get busy. Whatever can happen. Mistakes can be made, but having this robust, program is a really good defense. And whoever is the reviewer will often, I've heard it, I've been on the, prosecution side before, where they say, you know what, this person really was paying attention. This practice has a culture of compliance, and this was just a rogue employee or an honest mistake. This was not, this is not a non-compliant practice. And on the other side, if a practice doesn't pay attention, then they're going to just start with the fact that you're not taking the level of care required of a practice. And I mentioned board prosecutions because they're often related, right? The same things that become issues with the insurance companies can become issues with the board, can become issues with with not just commercial payers, but government payers, and then we can get into quasi or criminal actions. So these things are really often related. The other pitfall I see, and I'm probably saying the same thing in a different way, sending information to payers without checking first, am I required to provide this? Is the request narrowly tailored to a purpose that I can identify? Did the provider have the opportunity to review the record and information and be sure it's complete and accurate? And in most instances, discussion with counsel, if anything other than additional records are required for a particular claim. So this implies that there may come a situation where a request is made and the records are subpar, right? Or the records do not meet the standard, and it's clear and it's apparent. And you should not figure out what to do with that on your own. Talk to your healthcare counsel. They can, figure out the best way to handle that. Sometimes it's worth the fight to not disclose, right? And that has to be figured out on a case-by-case basis. If you're out of network, I do think you should carefully consider continuing to submit claims for your patient as a courtesy. A lot of providers don't understand that when you choose to be out of network, to not be beholden to a particular payer's rules, but you submit the claim as a courtesy for the patient. When you submit that claim, you check something or sign something that says, I'm agreeing to abide by your rules by submitting for payment of this claim. So, it's most protective if you don't do that and the patients pay for your services and they deal with the insurance company. It does mean that there'll be patients who are not willing to do that. However, again, that's a decision that has to be made between a provider and counsel, but I would say it's a pitfall to continue to process claims when you're out of network. All right, and that just goes right to special considerations for out of network. Again, seriously consider going cash only. I already explained why. I already explained that when you submit a claim, you're agreeing to the payer's terms. Collect co-payments and co-insurance and balance bill. And this is where it gets really tricky, right? Because when you're out of network, you're thinking, well, I can charge whatever I want. I'm no longer beholden to this. I'm not restricted to what the payer will reimburse, right? That gets tricky because if you do that, you have to be sure you're collecting the balance from the patient. And so, you shouldn't inflate the number, just collect the co-payment, and then just collect the co-insurance based on what the payer paid. That's not enough. You're also required to balance bill the rest. And a lot of people don't do that. Obviously, it's prohibitive, right? If you're putting a number there as your fee for a service that's not actually what you're expecting or willing to receive for that service. So be very careful there. And this is very nuanced and you should talk to counsel about this. But it's something certainly to watch out for. There's out of network no surprise billing law in New Jersey that basically says if you're out of network, you have to let your patients know that. It should be on your website, who you're in network with, who you're out of network with, and that when your patient is receiving a service, when they see you, it should be very clear if you're out of network with their payer. The obligation is on you. We have a lot of forms that say the obligation is on the patient to confirm whether a service is covered and or if the particular provider is in network for you. But the fact is that this law puts the onus on the provider to let the payer know who they are in network with. And I already talked about why we want to pay attention to the fee schedule. In healthcare, we have fair market value for everything. That's a term that is used over and over again, but your fee schedule should really be in line with the geographic area, your level of training, it really should not be inflated in order to increase the percentage you'll get paid from the payer. Any questions? Okay. I've talked here and there about what I do for my clients, what we say to our clients. And I just wanted to talk a little more about the things that we do for our clients that are related to payer matters. We already talked about the robust compliance strategy. And we do the training. We also have relationships with some really good coding advisors. So if it's a larger practice, the self-audit is not enough, and you'd want to engage a third party to come in and audit, and we can arrange for that. When you have a third party come in and self-audit you, having them engaged through your counsel makes it so whatever they find is protected by, it's privileged, right? It's the same as it's attorney-client protected information. That's better than engaging them directly. You won't have that protection if you engage them directly. So it's something to really consider. And, we are very often the first line of defense in dealing with the payers. We have been successful in, letting the payers know that our clients are protected, that we understand the rules and regulations, that we will take advantage of the appeals process, that we understand what a grab is and where it's permissible and where it's not. And there is always room for negotiation. I can't say that enough. There is always room for negotiation. I have learned, I ended up in a joint defense with a mentor of mine who, who I'd really admired over the years, really top-notch attorney in the healthcare world. And we were negotiating against one of the big payers for mutual clients that were in practice together. And I have never seen someone stick to this, what in my view was a very low offer. We're talking about 10% of the demand, which for me, I was, I thought, no way, we're going to get there. We can start there, but I'm pretty sure we're going to have to go up. And meeting after meeting after meeting after meeting, they wore those investigators down, and we were able to settle for that 10% number. It was really something to see. And I did learn that you just have to have the stamina and the persistence, and you have to have a client, the provider, willing to stick that out. Very often, the client, the provider says, this is taking too long, I just want to be done. And we end up having to settle for a higher amount, because they want to move on. But if you can stomach it, continue through the appeal, renegotiation, submission after submission to try to get that number down, because it very often works. It's also not cookie cutter. You have to be willing to be creative. I had a client who was just kind of really out of the box in that they were in functional medicine, and they had created their own template that they used. They had a unique practice approach, not a lot of patients. They spent a couple hours in visits with the patients. So they had created this form. Well, when they were audited and provided that form, the investigator was very, very confused and put them on a prepayment audit. And eventually, wanted some repayment. We were able, and this was a uniquely flexible and easy to work with investigator. She was just kind of open to listening to the provider. And I did something that I don't often do, which is I'll sit with the investigator and the provider to allow the provider to explain this form, right? I'm, legitimately rendered these services. This is what, this means, this summary means, and, And the investigator took the time to work with the provider and improve the form, right? Said, don't use a checklist. Don't, be sure you have a narrative field and be sure that there's something, different here. We have no idea what this, abbreviation means. You have to explain it. No one else knows. And they really, the prepayment audit continued for about a year until they got it right. And very little money had to be repaid. That is a really unique circumstances, but it's possible. It's possible. And what I want to say is we have to consider that there is not one cookie cutter approach, that we can be flexible, that we have to have a tolerance for negotiation. I do think that when people just kind of roll over and pay the money, that other payers somehow get wind, and all of a sudden you're being audited for the same code by a different payer. I don't know how they communicate that. I haven't been able to figure that out yet, but I do believe that they do. So any questions? I hope I didn't scare everyone. I want you to know that I do consider that the payers are trying not to pay. However, I think that within the organization, oh, you're welcome. Someone said thank you. You're welcome. Within the organization, the individuals that you're dealing with are still generally reasonable people that you can approach. It's getting hard to reach payers, harder and harder to reach the provider relations folks, but it can be done. You have to be persistent, but the hope is in that you start to talk to a reasonable person, that you wear them down, that you provide information in fact. And as providers, you're busy, you're not doing that. So you have to have kind of the right person to do it for you. All right, I think that we're just on time. We have 2 minutes left. If anyone has any other questions, or if Dr. Blumenthal or Josh, you want to make any closing remarks on behalf of the Medical Society?
Well, Council, I thank you for this interesting presentation. The first thing that I really carried away from it was the suggestion of having laminated sheets with criteria of codes for each provider. I find that very practical, and there were some other practical hints. So I do think that we shall share your slides through our website, right, Mr. Bengal?
Yeah, that's the plan.
Yes. Yes, feel free. This is good information. I hope people can take from this. All right. Well, thank you, everyone. And everyone have a good night and happy holidays. And please feel free to reach out if you want to discuss anything any further. Take care.